Welcome to part two of medical dispute resolution for medical bills denied for compensability, extent of injury, relatedness, or liability. This is day 6 of our boot camp series, and we've gone from the swing set obstacle course to this net challenge. We don't want you to get caught up in the net of denials for compensability, extent of injury, relatedness, or liability. So our learning objectives for today is for you to determine the steps to participate in a benefit review conference, know what to expect and how to prepare for that BRC, and understand what a final adjudication means. So let's get started in the content. This is part 2 of medical bills denied for compensability, extent of injury, relatedness, or liability. Part 1 is another video. And it is important to watch part 1 so you can get the precursor to this part 2 video. A little disclaimer to get started. We are educating system participants on this process, but ultimately it is your responsibility to know the laws and the rules. The laws are Texas Insurance Code, Texas Labor Code, and the Administrative Code. So if there's ever a discrepancy about what we've said today, the laws and the rules will help resolve that conflict. So know your laws and the rules. The overview of what we're talking about today is benefit dispute resolutions for you, the healthcare providers, as what we call subclaimants. Steps for participating in a benefit dispute resolution process for medical bills denied for CERL, compensable extent, relatedness, or liability. And some DWC resources. Part 1 taught you what is a CERL dispute, how to identify them, and maybe try to avoid them. Some of them are unavoidable. So you will need to know how to go through this dispute resolution process. And that's what we're going to talk about today. So what is a subclaimant? A healthcare provider can become a subclaimant and participate in these proceedings that the Division of Workers' Compensation holds. You can basically step into the shoes of the claimant and become a party to seek final adjudication on medical bills that were denied for compensability, extent of injury, relatedness of the charges to the compensable injury, or liability issues. Can you participate in benefit dispute resolution? Yes, if you establish yourself as a subclaimant, that means that you provided a benefit, and in this case, you've provided healthcare service, and you've received a denial for compensability, extent of injury, relatedness, or liability, CERL. So you may not participate in dispute resolution if you have not provided the service and received an EOB with a denial for CERL. So say you find out during the pre-authorization process, there's an outstanding dispute on compensability or extent. Unless you've provided service and received an EOB back, you cannot establish yourself as a subclaimant. But once you have provided that benefit and you've been denied, then you can establish yourself as a subclaimant and pursue dispute resolution. So benefit dispute resolution proceedings, basically they are conducted at virtually or in person at the Division of Workers' Compensation. There's going to be a presiding officer that works for DWC that helps you resolve one or more, and we call these benefit disputes. The levels of these proceedings start with benefit review conference first. We call those BRCs. Then if it's not resolved there, it goes on to a contested case hearing or arbitration. However, there are little to no cases going to arbitration, because if you do arbitration, there is no appeal process afterwards. Most cases go to a CCH, if not all cases go to a CCH after a BRC, if the BRC does not resolve it. And then after the contested case hearing has resulted in a decision, if someone is not happy, some party to that dispute, then they can go on to the appeals panel reviews. That's the next level at the Division of Workers' Compensation. Now, can the healthcare provider pursue dispute resolution without the injured employee's involvement? Yes, and that's conditional if there is no prior written agreement between the injured employee and the insurance carrier because maybe they've worked this out. So if there's no prior written agreement between those two parties and there's no final decision from the Division of Workers' Compensation on the issue in dispute, and you've received an EOB with a CERL denial, and there's also a PLN1 or 11 on file that matches that EOB, and the injured employee is not pursuing this dispute resolution process with reasonable diligence. So those are the ways that you can participate as a subclaimant. So let's go through the steps for you, the healthcare provider, to participate in these proceedings. So the first level was a benefit review conference, but there are some prerequisites for a healthcare provider to accomplish before they ask for that BRC. Number one, like all medical bill situations, if you receive an explanation of benefits that you are not satisfied with, the next step for you, whether it's a CERL denial or any other type of denial, is to ask for reconsideration of payment of medical bills. That's found in 133.250. So basically, you're going to try to resolve this, and we want those attempts to be meaningful between you and the carrier. So providing information is going to be important. So ask for reconsideration on the defense that has been presented on the EOB. I will have to caution you, sometimes you get a verbal denial. What matters is what the carrier puts in writing on that EOB, because that is the defense that they're using not to pay you. So that is the defense that you have to overcome. So pay attention to that. What's on the EOB is really important. So if you call Comp Connection and you say, hey, I've been denied, the first thing we're going to ask you is, what is on the EOB? So have your EOBs ready if you are going to call us about the denial. Now, once you start going through the request for reconsideration, I want you to document all your reasonable attempts to resolve this issue. This is required because the rule for requesting and setting a benefit review conference, 141.1, says that you're going to have that documentation. Also, to provide pertinent information. So you're going to look at the EOB and see what the reason is for the denial. And then you're going to pull pertinent information that speaks to that denial and that maybe will help overcome during requests for reconsideration. Pertinent information can be like medical records, emergency room reports, or better yet, causation information from your treating doctor. Causation is important, and we would recommend that treating doctors document from the first visit how this person got injured, what was happening, how did they fall, how did they get hit, how all the mechanism of injury. That's another way to say causation analysis is how did that injury happen. If your doctor is documenting on the first visit, second visit, after they get diagnosis codes assigned to that bill and they're documenting how they think that pertains to the injury, that is really important. Maybe they won't have to write a separate causation analysis if they're documenting very thoroughly at the beginning, the history and physical, how they fell, what happened, how did the wrist get broken because of the fall. Those kinds of things are really important in workers' compensation. And we've explained this in previous videos, but the workers' comp insurance carrier is only responsible for injuries or diagnoses that were caused by that incident. So ordinary diseases of life, the carrier is not responsible for. So picking through that, we rely on the doctor's expertise to go through that and give us a causation analysis. This is an analysis of clinical findings and timelines of when things happened and supporting medical literature. We have resources on our website for developing a causation analysis. We have a video out there from an orthopedic surgeon. Dr. Davis is explaining doctor to doctor what a causation analysis would look like and the compensable injury. We have sample treating doctor reports. If, say, your treating doctor did not document in the E&M notes very thoroughly, they can create a separate report, sample treating doctor report. There's a summary of best practices for preparing a causation analysis and resources for obtaining evidence. There's the link, but if you were to go to our website, it's under C for causation analysis. Make sure you're using the workers' compensation A through Z. Remember, we've showed you that. Look on your map and go to the workers' comp A through Z and go to C for causation to teach your doctors about documenting causation. That is really important. What makes workers' comp medical treatment a little different from any other payer system. So, number two, this is your second step. That is all, everything I've talked about so far is your first step. That's asking for reconsideration, that's developing content so that the carrier can see the doctor's opinion about causation and having a meaningful request for reconsideration. Number two, notify the injured employee, and this has to be in writing. We don't have a sample template of this letter, but there are certain things you need to include in writing to this injured employee, and that is that you intend to pursue dispute resolution for a claim for reimbursement for the benefit you've extended to that patient. You've provided services, you've been denied, you're pursuing dispute resolution. So you're going to tell them that. And they also need to know that, hey, if the decision from the division is that this condition that is, or this service was not related, or this condition is not work related, then you may be billing the patient at that point, and it could be binding against the injured employee. So you want to warn them that if you go through this dispute resolution process, it could be binding against them. Also, that they have resources. They, being the injured employee, can contact the Office of Injured Employee Counsel. We call this OIC. They provide free ombudsman service to the injured employee that's going through benefit dispute resolution if they don't have an attorney representing them. Here is the contact information. So each of these points needs to be in that letter to the injured employee before you request a BRC. So after you've done that, or at least document that you've attempted to do this as best you can, the next step, number three, is to submit the DWC form 045. It's called request to schedule, reschedule, or cancel a BRC. You can find all forms under F for forms, and then they're in numeric order. So you go down to the DWC form 045. Make sure you're not choosing the wrong 045 form. There's some with an M at the end. Just make sure you're getting the DWC form 045 to request the BRC. And you're going to send this to the Division of Workers' Compensation and to the insurance carrier, identifying yourself as a subclaimant. There's a box on that form to identify yourself as a subclaimant. This is part of you establishing your subclaimant rights. So complete and follow all the form instructions, including supporting documentation, and make sure you sign. If you don't sign this form and certify with your signature, it could be deemed incomplete. So make sure you follow the form instructions. Most of our forms on the second page have instructions for you. Include with the Form 45, documenting your request for reconsideration, because again, that's a prerequisite to get into the BRC. Correspondence, emails, faxes, records of telephone contacts with the adjuster, whoever. Make sure you're writing that into your patient accounting software so that you can produce it when you're filing your 45, or summaries of any meetings or telephone conversations you've had. Also, a copy of the letter you sent to the injured employee. We want to make sure the injured employees maintain their rights too. So letting them know that you're pursuing this final adjudication or dispute resolution is important. The medical bills are going to show that you provided services and that you were denied for CER or L. So the corresponding EOBs, and if you got copies of the plain language notice 1 or 11, put that all together. That establishes you as a subclaimant. Don't include the medical records at this point. It's just too much. Do not include pertinent information yet. but the EOBs, the medical bills, the copy of the letter, all of the things here, proof that you did request for reconsideration, and the Form 45. After we receive that packet from you, we're going to determine if the request is complete. Did you sign it? Did you send the letter? Did you do a request for reconsideration? If it's incomplete, DWC will notify the parties with a letter stating the reasons why you were denied access to a BRC. There is no deadline here, unlike medical fee dispute resolution or other types of like the pre-authorization process. You can ask for a BRC, you can resubmit it, and there's no 1-year deadline here. Now, if your request is complete, then a BRC will be set within 40 days. Now, if it's expedited, within 20 days. Sometimes for first responders, they will get expedited into a BRC. More information can be found in that rule 141.1, requesting and setting a benefit review conference. Then there's going to be exchange of information. After you've gotten your set notice, we're going to send you a DR01 that says you've been set for a BRC. You're going to need to know your deadlines. Read that set notice really well. Know your deadlines to exchange information with all the parties, which generally, once the BRC is set, 10 days to send the other parties your pertinent information, and at least 14 days before the BRC to us, DWC. Now, you're responsible for sending that information securely, confidentially. Label the information you're sending correctly, and don't send multiple copies. It's just going to slow down the process. So just send one copy, make sure it's labeled. And this is good to have organized for whoever's going to participate in the BRC. Have it tabbed, have it numbered, have your information that's easily accessible by everybody. Again, sending and exchanging information can be found in 141.4. You can learn more there and look at your set notice. So preparing for BRC. First, have a copy of all that information you've sent and that was exchanged. That person that's attending the BRC needs to be prepared. Know whether the dispute is for C, E, R, or L. You need to know what's on the EOB. You can have up to 2 EOBs there, right? The initial bill and the second bill. Just make sure what's in writing is going to be addressed in the BRC. Make sure you know what diagnosis codes they're talking about, what is said on the PLN 11 if you can get it, and be able to discuss any of the pertinent information, including the medical records, the causation analysis for compensability, extent of injury, or relatedness. So say you are a hospital, you're representing a hospital. Sometimes I've heard that there's a coding sheet that the coders use to put all the diagnosis codes on your UB. Make sure you've got that. The person that attends needs to be able to speak to every procedure code, every diagnosis code, anything in that medical record that needs to be talked about during that BRC. And so anyway, preparation is important. Be able to discuss what are the dates of service, what are the treatment and procedure codes and their descriptions, not just the ICD-10 code itself or procedure, ICD-10 procedures. Know what the narrative description of that. Have your book, have your whole explanation of what that is available to you, because those details really matter during this, because they're talking about conditions being treated and whether it's part of the injury or not. So diagnosis codes and descriptions, and also calculate out the maximum allowable reimbursement for the services that were denied, because you're going to need to know all of that when you attend a BRC and be ready to talk to the parties. And when the benefit review officer gives you that chance to talk, please be prepared. All BRCs are held virtually unless there's a good cause to have the BRC in person. So if you don't have internet access or the injured employee doesn't, sometimes they participate by phone. Any questions about that BRCs, you can call the number here, 512-804-4010, about the BRC that's set. Now, the BRCs are usually about 45 minutes or less. The individuals that may be present at a BRC, it would be possibly the injured employee and maybe their Office of Injured Employee representative, or maybe their attorney. The insurance carrier's representative will surely be there, and maybe other subclaimants. So maybe it's you, the hospital, the anesthesiologist, the treating doctor, the surgeon. All of them, if you've gotten your bill denied, they probably did too for the same reason. So other subclaimants can file and participate. So you may see them there. The employer may even be there. And of course, the DWC hearings officer will be there. Excuse me, hearings benefit review officer, the BRO, we call them. They'll definitely be there. But the other people may or may not be there. I think the insurance carrier representative will always be there. So that's who potentially could be there for that 45 minutes. The benefit review officer is in charge of organizing and running this meeting. They're going to help the parties identify the disputes. They're going to discuss the information of facts, get more information if needed, and they're working towards having an agreement. So this is the first step. It's a sort of a mediation, if you will, to try to get all the parties to know all the facts, and then maybe everybody agrees to an outcome. So say it's an arthritic condition, which could be attributed to ordinary disease of life. The patient's there, you're there, your doctor does not agree that it is part of the injury. I mean, we don't expect the doctors to always agree with the patient to say it is part of the injury. Come with his or her opinion there. They're a medical doctor, so they should have an opinion on whether the conditions on the bill are part of the injury or not. Maybe when the injured employee hears that, maybe they agree that it's not, and they sign saying it is not work related. Or maybe the opposite. Maybe everybody agrees that it is workers' comp, and there's an outcome, and that is a BDA, a benefit dispute agreement, a Form 24. You can learn more about BRCs under B in our topics A through Z, Benefit Review Conference. So there's a lot of information out on our website under that tab. You can see more at the rules under R for rules, a description of a benefit review conferences in 141.5. The BDA picture is on the left there for you to see. There's no section for a subclaimant to sign, I believe, but make sure you get a copy of that to go on to your next steps. So if the agreement was reached, a 24 is going to be issued. If the agreement has not been reached from all the parties, you, as a subclaimant, may request a contested case hearing, but it's up to the BRO, the benefit review officer. It's their discretion. They're in charge of that proceeding. There's a limit of 2 BRCs prior to a CCH. So the BRO could say, I need more information. I need to hold another BRC, and it's on this date during your first BRC. So it depends on what they say. So that could happen. Again, more about this in chapter 141.7. It outlines the division actions after a BRC. So if you've had the first BRC or maybe the second, the CCH is next if people have not agreed to an outcome. Contested case hearing. This is more like a case in court, basically. We're going to have an administrative law judge that presides over this hearing or this proceeding. And they are the ones that are going to make a decision and order on the disputed issues that were not resolved and agreed to at the BRC. You can find more information about how a contested case hearing works under C for contested case hearing. And that's also in chapter 142, dispute resolution, benefit contested case hearing. I put up a picture on the right there of that web page under C for contested case hearing. So the administrative law judge wants to hear from every party. This is a formal hearing, and it's important that all sides are heard so the administrative law judge can make a decision. Can you, the healthcare provider, participate as a subclaimant in a CCH? Yes, the same conditions apply. The subclaimant must show that the injured employee has been provided that written notice. So that letter to your injured employee is important. Keep it with the file. and you tried to contact them and the injured employee is not pursuing the dispute with reasonable diligence, or maybe you couldn't contact them. Please document that you couldn't find the injured employee and what you did to find them. That's important. The administrative law judge and our system, the claimant has rights, and we want to make sure they can exercise them. But sometimes they can't be found. So document that information. Once they hear all the evidence and they assess that, the administrative law judge, they will issue a decision and order. Usually they write those within 10 days after the hearing. The CCH decision is not appealed to the appeals panel until it becomes final at the end of the 15th working day after the date received from the hearings division. So after you get it, it's not a final adjudication until those days tick off and it becomes final and no one's appealed it. If you're a subclaimant, you should have a right to know what happens after this, if it's been appealed or not. So once a CCH decision and order becomes final, that means the days have ticked off, then the order should be complied with within 20 days of the date it became final. That means if the judge says, yes, these diagnosis codes, they are part of the injury. So it is workers' comp. It happened in the course and scope. It does extend to this body part. If it becomes final, the carrier has a duty to abide by a decision and the order. So the order is going to the party that needs to be into compliance, and they need to pay according to 408 and 413 of the Labor Code, which is our fee guidelines, or maybe it's a network claim and they pay according to the network contract. But they have 20 days, generally within 20 days of the date it becomes final, that they need to come into compliance with that order. If it happens to be appealed, that decision and order happens to be appealed, then it goes to the third and the final level of proceedings at the Division of Workers' Compensation. That's to our appeals panel. This is not where you show up. This is where appeals panel people review. It's an administrative paper review. They're going to look at written statements from the parties describing their position. So getting your position statements good from the beginning, right at reconsideration. Get it all together then, so you don't have to keep redoing it unless you need to add as you find out information during the BRC and CCH. The ALJ's decision is what they're going to review, and the record from the CCH. The appeals panel then issues a written decision. More about the appeals panel process can be found in Chapter 143, Dispute Resolution Review by the Appeals Panel. If a party of this dispute disagrees with the appeals panel decision, they're either going to uphold what the CCH did or overturn it. If the party is dissatisfied, then it comes out of our system, the DWC administrative remedies, and it goes out to a court of law for a decision. So it can keep going from there. Now, I'm going to go over some resources, but you've learned about the 3 levels of dispute resolution to get that final adjudication. BRC, CCH, and sometimes appeals panel. That is all provided to the patient and to the healthcare providers as subclaimants in our system. Now, to see a graphical illustration of the dispute paths and make sure you're going down the right path, we created this picture on the healthcare provider page. If you see in the middle, this is the green path that we're talking about today. The path on the left is for not medically necessary, and the path on the right are all other reasons. Remember, if you're in workers' comp, most denials probably center around either not medically necessary or compensability, extent, relatedness, or liability. If you have those 2 hurdles overcome, then most bills are paid correctly by insurance carrier. If you look at the total number of medical bills in our system versus how many are disputed, but all other reasons, if it's not medical necessity or CERL, it is a fee dispute. So don't go to fee dispute with a CERL denial. Go down that middle path and everything we've been talking about today with the Form 45. Also, there is a one-pager out there for the people that are pursuing dispute resolution out on our website under the healthcare provider page. It's right there. So what we've covered today is the benefit dispute resolution for healthcare providers as subclaimants, the steps to participate and benefit dispute resolution, and some resources for DWC. Now, I'm going to pull up that 5-question poll and see if we've done a good job here. Question number 1. What step needs to be taken prior to submitting the DWC Form 45 request to schedule, reschedule, or cancel a BRC as a subclaimant? What step needs to occur? And that is the first one. Attempt to resolve the extent of injury denial with the insurance carrier by asking for reconsideration. Most of y'all got it right. You may not bill the patient if you have an EOB denial for CERL until there's final adjudication. So ask for reconsideration. Don't pursue a private claim with the commercial insurance or bill the patient until you have final adjudication. Number 2, a healthcare provider must have proof that they notified the injured employee that they're pursuing dispute resolution for the CERL denial, which may be binding against that injured employee, and that OIC may assist the injured employee. That is true. You must have proof. That is a prerequisite to get into a BRC. Number 3, it is best practice to have a causation statement from the treating doctor prior to attending a BRC relating to a CERL dispute, and that is true. It is best practice. Number 4, when is a healthcare provider allowed to bill the injured employee for a medical bill denied for CERL? And that is after you, the healthcare provider, obtains a final adjudication from DWC that the condition treated is not work-related. That is true. You can't bill the injured employee if you just have the EOB or someone's told you to bill the injured employee. And even if you ask for reconsideration and it's denied for CERL, again, you still have to come to us for benefit dispute resolution and get final adjudication. Okay, number 5, at the most, how many BRCs can occur prior to a contested case hearing? The answer is 2. So they can have up to 2 BRCs before a CCH. Depends on what the benefit review officer decides. Thank you for participating in that. We flexed your knowledge and trained your brain there. Lastly, you can always contact us at Comp Connection 800-252-7031, option 3, or email us if you have further questions. Thank you for watching today's video.